I think we should start. Good evening again, everyone, and thanks for joining our live webinar this evening organized by the Osservatorio Golden Power. I'm Michele Carpagnano, and I'm really pleased to have our host today, Mr. Damien Levie, who is the head of Unit of Technology, Security and FDI Screening at the European Commission. Thanks, Mr. Levie, for accepting our invitation and for being with us this afternoon. The idea today is to speak... Good evening, thanks. The idea is to speak with Mr. Levie of the new reform of the FDI screening, which is in place in Europe. And we will take advantage of his experience, of his role in the European Commission. And also we will ask to the participants, we see they are a very good number this evening, to join us with live question using the platform of Zoom with the Q&A session. We will pick up questions and we'll try to answer during the webinar. 5 years at least have passed since the 2018 when the President of the European Commission, Jean-Claude Juncker, proposed the needing of a new screening, of a new mechanism at the European Union level for the screening of foreign direct investments. At that time, there was a lot of discussion among the academia, but also practitioners and experts in geopolitics, if this tool was really useful and was compliant with, the approach of the most important free economic area in the world, which was and still is the European Union. At that time, I remember that the press, especially the economists, remarked that less than half of member states in the European Union had in place a mechanism for the screening of foreign investments. Not only, but those few member states who had in place such kind of instrument of screening was completely limited in scope on very sensitive topics like defense, infrastructure, energy. Mr. Levie, 5 years later, the world has changed, and we can say that almost all member states, with some few exceptions in the European Union, have in place screenings for the foreign direct investments. There is a new framework in place, a cooperation mechanism, an exchange of information. You will tell us more in detail about how it works and why it is maybe time to rethink of a reform of this screening. So it's a great pleasure for us to have you with us this evening, and the floor is for you for the next 35-40 minutes. Thank you very much.
Thank you very much, Michele, and good evening, ladies and gentlemen, and thank you also for the Observatory of the Golden Power for inviting me tonight. I thought I would give you a state of play of the implementation of the EU FDI screening regulation, which was adopted in 2019, and so it's close to and has been in full force for a little more than 3 years. Next slide, please. So the content of my address today is, in a way, looking back and looking forward. Looking back, the journey so far, what have we achieved? And then looking forward, I'll give you our views on the assessment of the current regulation, which has created this new framework for screening of foreign direct investment inside the European Union. And then I'll say a few words on the next steps from here. As we have done last summer, a public consultation, so I'll give you a summary of the public consultation and say a few words on the revision. So the journey so far. So there you have indeed the timeline in the State of the Union of September 2017. Indeed, Jean-Claude Juncker made an important speech to the European Parliament talking about, I think, a geostrategic commission and presenting this new legislative proposal. At the time, and depending on how you count, we had either 12 member states with a formal screening, but if you really look more closely at the legislation in some member states, you find 2 more, but that they were not formally called screening mechanisms, but had a very equivalent effect. But anyway, between 12 and 14 member states with a screening. And 6 years later, we are 23, and I'll say a word on that. So April 2019, the regulation entered into force. It entered into full effect from October 2020. And this is from October 2020 that we have started screening cases on a daily basis. Next slide, please. So what are the main takeaways from these first 3 years of working together in the European Union, together among national authorities and European institutions, the Commission, on foreign direct investment cases? But first of all, that the cooperation is functioning very well. It's an example of multinational cooperation on investment screening. There's no other group of countries in the world doing this type of cooperation on cases, which is made possible, of course, by the whole setup of the EU and the way we work together on many other files. We have learned to work together in an area where we never worked together, at least not formally. There were the occasional phone calls between Rome and Paris, Rome and Berlin, or Paris, Berlin, or Rome, Madrid. But there wasn't a structure to systematically cooperate on cases. We have received in the first year, 21, 22, more or less the same number of cases. It started to increase in 2023. We have now received more than 1,200 transactions. And as is necessary for mergers and acquisitions, the EU cooperation mechanism, which is this set of 27 national authorities plus Commission, that's what we call the cooperation mechanism, is extremely fast. And that therefore doesn't have a delaying effect on the closing of transactions. Indeed, more than 80%, I think it's even 85% of the cases notified to the Commission are closed extremely fast within the first 15 calendar days without requiring an in-depth assessment, no need for further questions. And the percentage of cases closed by other member states is even higher or lower, but I think you understand depending on how you look at it. But I think the percentage of cases where member states open a phase 2 or ask questions is lower than the Commission percentage. Therefore, that's what allows me to say that the assessment by the Commission and by the member states does not delay the national screening procedures, while adding a very valuable cross-border dimension to the risk assessment performed by the member states, to the procedures done at the national level. However, despite the speed, we thoroughly screen cases, and we do spot transactions that are sensitive. While few of the cases, and you see it, lead to Commission opinions, I mean, cases less than 3% of the cases, where these have been issued, or issued. Our opinions have been extremely well received by the member states concerned, and this shows you that the Commission refrains from intervening frequently, and indeed our security and public order exceptions are interpreted in a narrow manner. And we don't pursue other objectives than security and public order. We do not pursue an industrial policy agenda or any other economic policy agenda. And finally, I think the numbers speak for themselves. The mechanism does not impede on the openness of the European Union to foreign direct investments. As you see, member states only block transactions in less than 1% of the cases. However, and that's another advantage, that the Commission brings to the assessment of cases an EU dimension. Our two main criteria for analysis and possible intervention are, on the one hand, is the security of two or more member states, security or public order, likely to be affected? So we look at, by definition, the cross-border dimension. We look at a case beyond the border of the member state where it is screened. We also look at projects and programs of EU interest, such as Galileo, European defense projects, Horizon Europe, Trans-European networks for telecom, transport, or energy. So if you want this EU cooperation mechanism, it really strengthens the national screening mechanism. It doesn't replace them, and it doesn't delay them, but it helps them and strengthens their analysis. We have also issued or set up, a secure way to exchange information. Confidentiality, as you can imagine, is key, because information exchange between national authorities and the Commission relates both to the commercial interest, CBI, so commercial business information of the parties to the transaction, but also to our national and European security interests. So a reason more to be extremely careful and respectful of the confidentiality. If you do the maths, we've had 1,200 transactions, more or less, a couple of documents per transaction. So it's in the thousands of pages, probably the hundreds of thousands of pages that we have exchanged among authorities in this cooperation mechanism. And there hasn't been a single leak. So this is really a watertight network of authorities. Next slide, please. Now, coming back to the issue of the member states, and I wanted to show you this map. As you can see, when it comes to member states, there are only two colors. If you look at our latest annual report, we also have a map with 4 colors, but I thought for today's presentation, we could just use 2 colors. Blue is the member states with a screening mechanism voted. There's one country that I could have put in a slightly different color. Purple could have been Ireland, because Ireland has voted but doesn't have yet a system in place. They still need to have some implementing regulations, and they are preparing all that and will have the system entering into force, I think, in the spring of next year. And then you have 4 countries that are in orange on my map: Croatia, Greece, Bulgaria, and Cyprus, which are preparing legislation. There are different stages of the process, some more internal, some more visible in the parliament. But I would say it's fair to say all the member states are working on something at different stages, as I said, of advancement. If I had shown you this map, like Michele said, in 2017 or 2019, you would have had much more orange. So we are really coming close to a map that would be entirely blue. And if you were to look at an economic map, so if you would do a weighting of this, you would see that when the Irish system is fully operational, we cover, I think, way above 90% of all FDI in value, and maybe even in a number of transactions. So we've really gone a very long way in ensuring that the Union is protecting itself better from possibly risky transactions. And again, before we move to the next slide, the last bullet on this slide says that, and we've asked the question a few times in the last 3 years to member states, they really view the cooperation mechanism very positively because it gives them first an oversight of FDI going into other member states. Before that, they didn't have a system to know what is happening, what other transactions are taking place in, if you want, in their neighbors. It gives, as I said, a very valuable tool for close contact between screening authorities. But also when other member states notify transactions, it does happen that you then become aware of the transaction that has a direct effect on your country. The best example of this is because the target group has an affiliate company on your own territory. The usual example is an Austrian subsidiary of a German company being taken over. Sometimes, at least in the beginning, for example, lawyers tended to forget, the Austrian notification. But then Austria in my example, but that can happen in all kinds of directions, of course. It's just an hypothetical example. Austria in my example would then request a notification by contacting the CEO or the management of the Austrian company. So that has been also another very positive element of the regulation. I think more broadly, all the member states consider that the comments received from other member states, the opinions received from the Commission help them making a better assessment and taking a much better decision. So that is, in a nutshell, ladies and gentlemen, that concludes my the first part of my introduction, of my intervention. So the journey so far, what have we achieved in terms of coverage of transactions, the member states, how we work, the percentage of cases, the number of cases, that it does not delay transactions, and that the EU remains extremely open to much needed foreign direct investment. Then the next slide will, with the next slide, I will start the second part of my expose, of my keynote address tonight. Is under the regulation, we had to do an assessment, an evaluation of the regulation after 3 years. And so we've launched that before the summer, and we've done a public consultation. We've done a consultation of the member states authorities. We've done some targeted questions to some stakeholders who are really practitioners of FDI screening. And that we have organized our questions according to the normal criteria to assess legislation in the European Union, so-called better regulation principles, where you look at the design of a regulation, you look at the effectiveness, the efficiency, the value added of a regulation, the coherence between the policy you pursue under this instrument, control for foreign investment, with other instruments that are in place. So we follow the normal analytical grid of the Commission for better regulation. Now, looking at the design of the regulation, there is, of course, the first observation is that there's no requirement in the regulation to set up an FDI screening mechanism. So under the current law in the EU, member states are free to control or not to control foreign investment. Since 2019, the Commission has issued a number of communications, so has taken a view politically that all the member states should have one, but legally under the law today, member states do not have to set up an EU FDI, an FDI screening regime. Second observation one can make is that the national regimes are rather heterogeneous, and that concerns the procedures, but also the time frames, but also the technologies, the sectors that are covered, also the types of transactions. Not all the existing regimes are ex-ante authorization regimes. Some, at least one, is an ex-post regime where the government always has the possibility to review a transaction that has already taken place. To my knowledge, in that country, the government has never exercised this possibility. But you also have, so you have the freedom to control, not to control. You have the freedom to design the sectors which are controlled and not controlled, or in which transactions taking place are controlled or not. You have the freedom to design and decide which transactions are controlled. You have the freedom to decide, is it before that acquisition takes place or is it after? You also have no obligation for a member state screening a transaction, receiving formal comments from one or more other member states and from the Commission that the transaction that member state is screening could threaten the security or the public order of these other member states or European assets. The member state screening does not have the obligation to explain to the others what it's doing. It must take it into account, but there's no feedback loop. There's no organized feedback loop. And finally, the regulation does not cover investments done by subsidiaries established under EU law, or one of the laws of the 27 member states, but controlled by foreign countries. So, for example, a very frequent type of transaction, the foreign investor could set up a subsidiary in, for example, Luxembourg. And then you have a newly established company in Luxembourg doing the acquisition, for example, in Italy. Or sometimes the investor is from a third country, but setting up a company in Italy, which is then the formal acquirer of the shares of the Italian business. I presume this is done for tax purposes, but maybe for other purposes as well. And if the investor from a third country buys directly, those transactions are covered by the EU regulation. Therefore, the cooperation mechanism applies. The phase 1, phase 2 notification and all that mechanism applies. If the foreign investor invests through an EU entity, and we cannot establish that that EU entity is in a way a circumvention, is a case of circumvention, that acquisition through an EU entity is a case of circumvention, because the EU entity would have a real economic history, employees, activities, so it's not a shell company. Then we can only observe that the regulation has a loophole, because we cannot cooperate on these intra-EU transactions, even if the investor from the European Union is fully controlled by a third country investor. And the transaction would pose exactly the same risks. From a security point of view, there would be absolutely no difference if it's directly or indirect. Can you switch to the next slide, please? Thank you. Those were, in a way, the main shortcomings we saw when it comes to the design of the regulation. Then we started looking also at the way the regulation is implemented and the way it is more particularly implemented at the national level, because as you, something I didn't say, but it's very important to keep in mind, the front office, the front desk for all transactions is the member state's screening authority. Lawyers for an investor never go to the other authorities. In my example of a German company, of an Italian company being taken over, you always have lawyers going to the Italian authorities. That's the front desk. That's where you submit your file. And then that authority, the Italian authority in my example, will then notify the case to the 26 other national authorities, plus the Commission. And then, therefore, it's very important to know how the front office, if you want, interacts with, I wouldn't call it the back office, but the other authorities that are in second line. So the first line of contact, of investigation, of analysis, and ultimately of decision is always the national screening authority, so the authority screening relevant transactions. So when we looked at the way the regulation is implemented, we were interested in the following question. When you are a screening authority and you receive comments from other member states, you receive an opinion from these guys in Brussels, the European Commission, what do? Do you have the power, the legal power to do anything about these security concerns of your fellow member states? And the answer is it depends. It depends. Some member states have the power, the formal legal power, some don't. And that's an issue, of course, because it's so nice and well to have a European regulation that says member states should take into account the comments expressed by other member states and by the European Commission. But if they don't have the legal power to do so under national law, the question is whether they can do anything. Some do. Some have explicitly foreseen in their legislation, Germany, for example, that they are allowed to take into account comments from other member states and from the Commission, therefore have the power to impose measures, possibly even, I suppose, prohibit a transaction if the security of other member states is likely to be affected. Another question is in this interaction between, if you want, the first line of investigation and decision and the second line. Another question is whether a national screening authority has the power to ask questions about what's happening beyond its borders. In my example, the Italian entity is providing, let's say, widgets to the German army. Well, do you have the power to ask questions about activities in Germany? Would you also have power to ask questions to entities established under German law? Maybe, maybe not. That's also an interesting reason. Then that's, if you want, the issue of the legal basis. Then you also have a separate issue, which is kind of the design, if you want, but it's the heterogeneity of sectors covered, transactions covered. For example, greenfield investments may or may not be covered by some member states, and that may or may not be an issue. Next slide, please. Right. Now, let me summarize the comments received in this public consultation that we held over the summer. We also did a call for evidence. And I think we received about 50 comments. I think it's important to review a bit the comments received, because that will give you, I think, a good overview of the opinion of stakeholders, authorities on this legislation. First of all, we asked the question of relevance. Is this regulation relevant? Is it still serving a purpose. There, the overwhelming majority considered that, more than 80%, the objective of protecting security and public order from the risks posed by certain foreign direct investments is still relevant. And the percentage was even higher for member states' authorities. We also asked the question about the value added, which is, you compare your counterfactual is what would have happened if there were no EU regulation. And there, the respondents agree that the regulation has increased the effective protection of security and public order from risks posed by these risky foreign direct investment beyond what would have been achieved by member states operating individually without this framework that I talked about, between the first line and the second line. We also looked at some other questions, for example, whether or not the regulation has increased the convergence between national rules on issues such as what is a risk to security or public order, or how do you assess security or public order risks? I think there the answers are more nuanced. Same when it comes to procedural aspects of national screening mechanisms. I can say a word on that. I can say a word that the regulation was never meant to achieve convergence in this, but it could have happened nevertheless, but it hasn't happened. So after relevance, is it relevant? Overwhelming yes. Does it add value? Yes, absolutely. Even if it has not increased convergence on what is security, how you assess a security risk, and on the procedural aspects, including timelines of national procedures. Third criteria in our analytical grid, a better regulation grid we looked at, is effectiveness. There, the respondents consider that the regulation has significantly helped the member states, the Commission, to identify risky transactions. So it's been actually effective. The respondents also confirm that while screening rules might be taken into consideration in certain business decisions, the existence of FDI screening under national rules and with the EU framework is not as such a deterrent to foreign direct investment. That was a very important finding in the public consultation, because remember, we don't want to deter foreign direct investment. It's very important that the Union remains open. Now, we also ask a question on who should be investigating and taking decisions. There was a very strong preference for maintaining the primary role of the member states where the foreign direct investment is planned, albeit in close cooperation with other member states and the Commission. You could have thought, oh, maybe everybody will want to centralize this in Brussels and, ask these European officials in Brussels to take over and become the first line of analysis, control, investigation. That's not at all the responses we have received in the public consultation. Another finding was that there is strong support for covering transactions where the direct investor is established in the European Union and ultimately controlled by a person or an undertaking from outside the European Union. And there was also support for laying down a minimum set of sectors, considerable support even, to have a minimum set of sectors, kind of the hardcore, that should be covered by all member states. After relevance, value added, effectiveness, I told you it's a pretty formalistic analytical grid or grid of analysis. we looked at efficiency. There, the respondents overall agreed that the cooperation mechanism puts a reasonable burden, administrative burden, on the parties, although it's fair to say that the replies received from business associations, companies, or trade unions were more nuanced. Public authorities were also looking at this slightly differently. Some member states were looking at it also when you're on the receiving end of filings and notifications, that this might be too much. But overall, when it comes to efficiency and the reasonableness of administrative burden, everybody agrees that the burden is reasonable, in particular for transactions that may pose a risk to security or public order. Then we ask questions about harmonization of timelines and whether the lack of harmonization is an impediment to the efficiency of the cooperation mechanism. And there, I think the answer is yes, we should have more harmonization in the timelines. You know, it is so that more than 20 or even 25% of our transactions are multi-country transactions. So in my example of this Italian company being acquired, you would often have one or two affiliates in other member states where the investor would also need to file an authorization. And then the investor not only has to manage one authority, but has to manage 2, 3, 4, sometimes up to 10 authorities screening inside the European Union. And then if you have one in the UK, one more, and then that could be even more if you acquire larger corporate groups. So the lack of harmonization of timelines and procedures is really seen by respondents as limiting the efficiency of the overall system. Then we also looked at to see whether the cooperation mechanism is efficient. What are the criteria for authorities, screening authorities, to notify cases to the cooperation mechanism? What is the filtering? What is the filter? What is the criteria? When do national authorities have to notify cases? For the moment, if a case is undergoing screening, which means in a way kind of formal screening, then it has to be notified. And some member states notify us all the cases they receive. Others take a different approach. They do some kind of informal screening first, and then they only do a formal screening for cases that are more sensitive. And there, in the public consultation, there is support for having some common criteria, which would be risk-based criteria, as opposed to the formal one, which is today's is a case undergoing screening, which is a more formalistic criteria for notification. We also asked questions on this issue of pre-screening, which does not receive much support in our public consultation. Then, last but not least, on this issue of efficiency, there was quite a little bit of support for more transparency, more information from member states and the Commission in the annual reports on FDI screening, proposing that some common minimum requirements would apply for the content and the reporting methodology of the member states' annual reports. Then lastly, in our analytical grid, we also looked at coherence, as I said, on coherence between the FDI screening regulation and other authorization procedures, like the EU merger regulation, or sometimes specific procedures applicable in regulated sectors, like the financial sector or the energy sector. The replies were divided. We received some detailed contributions on the interaction between merger control and screening. Some pointed to differences in the concepts of control, of ownership, and that one test is looking more at economic test, significant impediment of effective competition, as opposed to security. And I think some respondents were also saying that it's an issue if you have competition authorities clearing a case and screening authorities prohibiting a case. Personally, I fail to see it's an issue. I mean, I understand the difficulty, but it could very well be that a case does not raise competition concerns, so it's fine from an economic perspective, but from a security perspective, you do a very different analysis, or vice versa. It could be that a case does not raise any security concern, but does raise competition concerns. That I think is the natural consequence of having different controls applied for different purposes.
Damien, sorry if I may jump in
No,
here, because it's a very interesting topic, which is a cross between competition, antitrust, and FDI. I fully agree with you. I mean, if there is a veto decision, the veto should prevail because they are a completely different set of norms. But what about, and my question is, if you see something already, if you have seen something already in practice regarding the commitments, because we know that sometimes the parties are willing to offer commitments during the FDI screening process in order to get, a softer approach by the authority, the national authority, or in some cases it's the same government that imposes commitments. So what happens if the commitments, which are perfectly in line under FDI screening, may pose some competition concerns? It's something that have been already appeared in your desk in Europe?
Well, maybe you could give an example of which commitments could raise some competition concerns?
Well, thanks.
Because I think for the audience, otherwise it remains a very hypothetical example, or it could, well, maybe, but
Sure.
what would be the example?
Well, for instance, if we are talking about a critical asset, which provide a critical source of supply for a specific industry, and so the government, in order to allow, but I'm thinking loudly, it's not something prepared, just to and the government, in order to secure the provision of supply at the national level, imposes, for instance, an exclusive, provision of supply, which lasts more than 5 years, or more than it is normally reasonable, acceptable under competition law. So from one hand, you secure the supply, but maybe from the other hand, you are undermining competition in the market.
I'm not aware of any such example. I mean, the issue of disruption of supply of critical goods and services is one that pops up in our cases that of course we look at when we look at suppliers of goods and services that are sensitive for security or public order. But typically the member state will be concerned that the target will stop supplying. And so what the governments typically want is assurances that there will be continuity of supply. I'm not aware of any government signing an exclusivity deal. They want to make sure there is still one supplier in the market supplying the goods and services it needs. So I think the time horizon is also usually quite limited in time. So again, I think it's an interesting theoretical discussion that we may wish to further develop later on. But I've heard this concern, but I've never seen a case. So, but we've only handled 1,200 cases. I don't know how many notifications there have been under the EU merger regulation, but it's been in place for 30 years. So probably dozens, tens of thousands. We can go back to archives and find cases. So let's see. I don't exclude that there would be indeed such a possibility. but that's kind of the nature of having to handle parallel procedures with very little organized bridges of information. The information you receive on screening, you can only use it for screening. The information you receive in the merger regulation filing, you can only use it for merger regulation filing. So the authorities are not allowed to talk to each other. So I'm afraid for the moment we don't have also the legal means to discuss any such issue, assuming it would occur. But I cannot exclude it would one day occur. Yeah.
Thank you. Thank you very much.
Thank you. So that, if you want, concludes the summary of the comments we received in the public consultation. Then, about 2 years ago, we received a letter from the European Court of Auditors informing us that they were going to launch in 2022 an audit of the EU FDI screening regulation. Of course, you can imagine that you are always a bit surprised when you get such a letter and you wonder what will happen to you, because you have these people you've never dealt with, at least not directly, have been involved indirectly in some other audits, from Luxembourg, who are very good colleagues, but who tell you, knock, 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 I want to know how you work. And they really wanted to help us prepare this evaluation that they knew we had to do after 3 years. So you can show the next slide, Michele. Earlier this month, they published the result of their audit. The court was the first outside institution that received access to our files, which is normal standard practice, and the arrangements, the formal arrangements between the Court of Auditors on one side and the European Commission on the other side, but with due respect of and with necessary precautions for the confidential information contained in our documents. And so if I can look at the main recommendations from the court also acknowledges the achievements of the regulation and thus give us good marks and says that we've actually done a good job in implementing, we have sufficient resources. But they also took the time to look at the design of the regulation, wanting to help us in identifying shortcomings and proposing solutions to that in our upcoming legislative proposal. So they identified shortcomings in the design of the regulation. You would not be surprised, because they looked at indeed the number of member states with screening legislation, that indeed there are still a few member states that don't have a screening legislation. They also point to possible blind spots caused by the lack of harmonization of scope of transactions, scope of sectors. Also, the fact that the regulation does not apply to intra-EU transactions, even if the EU investor is controlled by an entity from a third country. They consider that it's also a potential issue if we do not define certain concepts like portfolio investment or greenfield investments. And the lack of harmonization of these concepts may lead to different practices and potentially suboptimal outcomes. They also identified in the design of the regulation the lack of accountability of member states, the screening member state, as I explained earlier. So these are a few comments and recommendations the Court of Auditors has made. If you want, the opinion of the court is available online. From our perspective, we consider that we've started to implement the recommendations. We have improved our notification forms. We have an actual use of our procedures. We make sure we use it all the time, because auditors check whether you always apply your procedures. And we also pursue informal conversations among national authorities in the case of multi-country deals, which is one of the main phenomenon that was not at all identified by the regulation of 2019, and it's still a pretty sizable chunk. Sorry, let me just, sorry, I was being called by someone. Let me turn off that device. Apologies for this. I forgot to put myself on do not disturb. Okay,
No problem.
very good. Do you hear me?
Yeah, perfectly.
Okay, very good. Excellent. And second, we have said that we will address further shortcomings in our legislative proposal that will be coming from the Commission. So, for example, the lack of harmonization of scope and timelines, the lack of requirement for member states to have a screening mechanism, the lack of accountability, the lack of feedback loop and so forth. These are things that we can take care of in our legislative proposal. Next slide. Thank you. So what also happened this year is that the Commission in June adopted a communication on economic security strategy. So for the first time, the Commission has issued this, and it's a very interesting communication because it really invites the member states, the business community, to start thinking in a structured way about risks to our security of a number of economic activities, and proposes a conceptual framework to look at economic security, and announces that it will launch a number of work strands under 3 pillars, or also announces, proposes 3 pillars of actions. Promote a number of sectors that are important for our competitiveness and our security. Protect, be it protect our technology, protect infrastructure, protect sources of supply, and partner, because we don't live in autarky, and we have to partner with different countries on different issues, and not only with like-minded partners, but also with others, to make sure we have as strong an economic security as possible. So it's really conceptually an important programmatic document, if I can call it that way, that I invite you to have a look at. In my unit, we have been tasked with projects more on the protect side. And when it comes to FDI screening, the Commission announced that it kind of knew the conclusion of the evaluation, what was ongoing, because the shortcomings identified were significant enough that the Commission announced a legislative proposal to revise the EU FDI screening regulation. Now, this proposal is under revision, is under preparation. A text exists, but it's subject to the normal consultation among different departments. And I can tell you that it really looks at the shortcomings I've presented to you. So if and when you will see this legislative proposal, you will not be surprised, because it will be the logical consequence, logical next steps. And if you've listened very carefully to how I've presented these shortcomings, you will then understand what will be coming. And I would say we've looked at this rather logically, looking at, do we see all the cases? Does the cooperation mechanism review all the cases? Or do we miss some? Well, the answer is yes, we do miss some, as I've explained. Member states have the freedom to screen, not to screen. Member states have the freedom to determine the scope of the legislation, scope of transactions, scope of sectors, ex ante, ex post. Do we see too many? Maybe we do see too many cases. Do we need risk-based filters or not? And if so, which types of risk-based filters? Is the framework effective? Do the member states in first line, second line have the legal powers to do what they are supposed to do for this network of authorities to work together and collectively protect effectively our security? So these are the issues we will address, or we are addressing in our proposal. Next slide. And don't worry, now I come to the end. So the Commission in January will adopt a package of initiatives. You will see a legislative proposal on FDI screening based on our 1,200 experience of 1,200 cases, based on our public consultation, the evaluation we've done, the report of the European Court of Auditors. So it's a very strong evidence basis. We will also, that's probably less of interest to the people on this call, but make a proposal to improve the effectiveness and efficiency of the framework to control export of dual-use items. We have started since June to look at also different types of transactions which are outbound investments. Outbound investments are investments made by EU citizens, EU companies in countries outside the European Union, where we have started to analyze whether certain transactions, certain types of transactions in certain sectors might pose risks of leakage of sensitive technology for our security, where you could see EU companies making investments in certain countries that pursue civil-military fusion programs, and that could use the technology that is being transferred by a European company to their territory, maybe in a joint venture, for example, and they could use some of that technology to further their own military programs. Fourthly and fifth, less relevant again for this group, we are also looking at proposals to support research and innovation for dual-use technologies, and also a proposal to improve the research security inside the European Union. When you think about it, and when you look at the literature, Europe is still extremely strong in research. We are very, very good in inventing new things, in discovering new things. We are less good at transforming that into market applications and products and services, but still in research, we are still very much world-class, depending on the sector, but we are still extremely strong. Therefore, it's very important to protect the results of our research from the same nefarious actors. And this is an area which is not easy because, of course, researchers, they love to cooperate with everybody. They think the outcome of research is a public good, and science belongs to everybody. And you need to strike the balance between, indeed, this public good dimension of science with the security aspects of it, that, well, certain scientific discoveries and research can be very much used for dual-use purposes, or in ways that are undermining or could undermine in the future our own security. So we will be striking that balance in the field of research. So, ladies and gentlemen, that brings me to the end of my presentation. Obviously, I hope you enjoyed it. So, just to summarize the journey so far, you've seen the number of member states and how it's been working. Very positive. I've tried to present to you a summary of our assessment of the regulation as it works, of the cooperation mechanism as it works today between the 27 member states and the Commission. And I've tried to summarize to you or present, if you want, our assessment and what are the next steps going forward. And so stay tuned. Thank you.
Thank you very much, Damien, for this very clear and detailed description of this very interesting and intense journey so far. And we look very much forward to reading and studying the new package that will be published in January or in the beginning of the new year. While we are waiting for some questions from the audience, maybe I can start with a couple of questions. But I mean, I mean, your presentation was very insightful and very, very deep of food for thoughts. But for instance, you mentioned, and it is very clear that the aim of the screening of the regulation is to screen extra EU investments. But we know that in some member states, and Italy is one of them, there is also specific attention to intra-EU investments for specific areas, of course. So do you think that is something temporary because of the specificity of the geopolitical situation that we are living, especially after the pandemic and the very sad events that we all know, or it's something that is in a certain way compatible with the overall screening and the legislation that we will expect in the next future?
Yeah, thank you, Michele. It touches upon an important freedom, of course. If you remember the Brexit conversations and the conversations, you cannot have the cake and eat it. It was all about the 4 freedoms of the internal market. It was all about free movement of goods, of services, of capital, and of people, right? If you belong to the union, you cannot pick and choose. You have to take the 4, and you cannot restrict immigration, for example. The same logic of free flow of goods, services, people, and capital is really the cornerstone of our internal market. That's really the main reason why having an internal market has increased competitiveness and has been a source of prosperity. Therefore, when a member state controls intra-EU transactions, it is potentially erecting barriers to the free flow of capital and creates all kinds of situations and possible concerns, whether it is, why is it doing so? Is it doing so to favor certain companies over others? Is it discrimination? Is it some other concerns that are driving this? So this is where the colleagues of DG FISMA in the Commission, who are in charge of the internal market when it comes to financial services and free flow of capital, have been keeping a very close eye on this process, and where the Court of Justice in a recent case last July, the Xela judgment, which was a Hungarian case, an acquisition of a quarry with, if I recall correctly, something like 20% or 15% market share of the sand and stones used in Hungary for the construction of houses and buildings, and where the Hungarian authorities apparently have considered that acquisition was causing a threat to the security of supply of an important strategic good to Hungary. The case is still ongoing because the Court of Justice responded to a preliminary ruling by the Hungarian courts, and now they have to take a final decision. And I think it's fair to say that the Court of Justice was looking at this case with a lot of skepticism, that he was not convinced that this was meeting the relevant criteria under the free movement of capital and the freedom of establishment, even more important, inside the European Union. So I don't have a crystal ball. I cannot tell you whether there'll be more or less, but I think member states have to be very, very careful when it comes to this, the review of intra-EU transactions. And I think the more you focus on foreign ownership, non-EU ownership, I think, and you really show the security dimension of these, but established security dimension of this, I think the better.
Thank you. Thank you also for your view on this very important line of evolution of this very important piece of law. I think we are perfectly in time, Damien, and I thank you very much for your time and for your discussion, very open and illustrative with us today. I don't know if you want to make a final remark, or we can close here. We are just 1 minute more.
Excellent. No, well, thank you very much, ladies and gentlemen, for your time and for your attention. Even if you didn't have any questions or comments, I think it's an important field of law that will further evolve over time. And I hope that collectively we can learn from each other and learn from our best practices. The Italian authorities, for example, have this excellent practice of a very detailed annual report summarizing all the cases, the important cases it has reviewed. It's a leader in that field. I don't know of any national authority doing the same. And so I think we can all learn from each other and further improve the excellent collaboration that we have had. Well, thank you very much for your time and for inviting me tonight.
Thanks, Damien. Actually, my final remark from my side, actually, during this journey, which was, as I said, as Damien also recalled, very intense, but in a very short period of time, I think that one of the most valuable things is that the community of lawyers, a community of specialists, a community of officials across Europe have been exchanging views, opinion on very important pieces of law and practice. And it recalls to me what happened at the beginning of the competition law in the very early stage of our community, that, at the beginning was very difficult to interact with new pieces of law, but then through also the big effort of European institutions and the European Commission, the European Court of Justice, all this flourished in a very harmonious and very constructive way for everybody. So this is our maybe best wish for the future for the FDI laws also. And this is the last webinar of this year. So I'm very happy to conclude with Damien. It's a great host tonight, and look forward to new webinars, a new occasion of interactions also with the European Commission in the next during the next year. So thank you very much again, and see you soon.
Thank you very much.
Bye-bye. Thank you.